time helping Scott with kind of administering the discharge upgrade program for the LA and Orange County offices. So we are, I think we're kind of in, I know some of you have worked on these cases before, some have already onboarded, and we're looking to place 3 more cases today and hopefully more throughout the year. So we really appreciate everybody for attending. I've been doing these cases for a couple of years now. I've found them incredibly rewarding and fulfilling and challenging work. Sometimes they can kind of test your kind of feelings with the system that has been created to review these cases, but it's really great work to be doing for those of us lawyers who are really, most lawyers, which is taking in a challenging case, building a story, looking at the evidence, and kind of, having the creative freedom to tell this service member's story in a way that does justice by them. So I thank everyone for attending. We have in the packet that you got when you first got here, one of the printouts is a couple paragraph summary of the 3 new cases that we have. We'd like to place them at the end of this meeting if possible. So during this training, if you guys could just take a look, see, if any of them in particular may, interest you. They all do need to be placed, and generally, we need a partner in charge and at least 1 associate. I think if you're an associate who has not done a case before, we would encourage maybe 2 associates to be staffed on that case. And I will make myself available to be, assisting in an advisement role as an associate as well on any of these cases. So, and I may take one myself depending on what happens. But you will not be alone if you haven't done this before. There's a bunch of partners and associates in this firm who have done these cases before and have run them very capably. So we thank you, and turn it over to Kara. I think Kara and Amanda, or are you gonna? Yeah. Okay. All right. Thank you, everyone.
Thank you. Hi, everybody. My name is Vidya Raghunathan. I'm the Pro Bono Coordinator at Inner City Law Center. And again, thank you guys for being here. We're hoping this process of a long training is made a little less painful by the fact that you get MCLE credit as well. But the focus of the presentation really is to highlight one of the things that Inner City Law Center does, the types of cases that our homeless veterans team takes on and the need for it. So for those of you who don't know a lot about us, Inner City Law Center, we've been around for about 38 years now, and we really focus on housing and homelessness. So our goal is to tackle the homelessness crisis in LA, which even out here on the west side, I know you guys see, and you guys see probably more and more every single day and every single year. And to ensure that every resident of the city has access to safe and affordable housing. And almost at the very top of that list, if not at the top of that list, are the people who served for this country. So Kara and Amanda, Kara is the director of our Homeless Veterans Project. Amanda is one of the staff attorneys, and they will be walking you through the process for what a discharge upgrade even is, because if you haven't worked on one of these cases or are familiar with the military and the way it runs, even that phrase is confusing. So just realizing what that means, what your role is going to be, how you're going to work on one of these cases will all be laid out hopefully very clearly. The way we do pro bono at our office may be similar to what you've done with other organizations and cases. It might be very different. We will place all of the cases that we brought with us today with any and all of you, and then you are assigned to one of our staff attorneys who will be your liaison through that case. So yes, you've done the training, you're going to have a fantastic start, but we know you're going to have questions as you go along. You may want to talk strategy, you may need sample documents, you may want one of our attorneys who does these on a daily basis to review final drafts of your briefs, to facilitate an introduction to the client, and we will do all of that for you. We want you to take the lead. Like Brandon said, we want you to be creative. We want you to think of this as your client and your case, because it is. But we will always be there, standing next to you if you need guidance, or have any questions. We just ask that you keep us informed of any major developments in the case, just so we can step in and help if that need comes up. But otherwise, we are really excited to partner with you. And I'm going to now turn it over to Kara and Amanda.
Good afternoon, everyone. So I am Amanda. And so obviously we're here today to talk about bad paper, and you'll find out a little more about what that means in just a minute. So just an overview of what we're going to cover today. We're going to an intro into Inner City Law Center and what we do. We're going to talk about bad paper in terms of veteran eligibility and mental health, discharge upgrades, procedural guidance, and culturally competent practice. So by the end of this, here's some objectives we want, hopefully, to get across. Understand the connection between bad paper and mental health. For you guys to be able to state the standards for discharge upgrades, to describe the discharge upgrade process, identify the elements, and compile a comprehensive discharge upgrade application. And we'll talk more about this, but it'll include the veteran's sworn statements, a letter from a friend, a letter from a physician, and probably also an advocacy brief. And then also foster effective communication when working with veterans. So Inner City Law Center, we have a number of projects. It was established in 1980 by a UCLA law grad. It remains the only full-time legal services provider on Skid Row. And although we did just open a new building in the One Wilshire, or a new office in the One Wilshire building, the VETS project remains on Skid Row, though. It's easier a lot of times for our clients to get there, and it's just more available. And so the Homeless Veterans Project advocates on behalf of homeless veterans with mental and physical disabilities, including post-traumatic stress, military, sexual trauma, and traumatic brain injury. We provide a range of services to address the significant barriers that a lot of our clients face. We represent veterans with discharge upgrades, with VA benefits, and traffic tickets. Many of our clients have a number of these issues, but removing just one of them can create increase their wellness overall. So there's over 40,000 homeless veterans in the United States, and Los Angeles remains to keep the shameful title of the homeless veterans capital of the United States, with over 4,000 in LA alone. And 90% of our clients that we assist at Inner City are homeless. We get many of them through shelters, but we also partner with medical legal partnerships and also other partner organizations who also address homelessness. There's no official data about with inequitable low discharge statuses, but thousands seek upgrades each year, and definitely thousands are not granted each year. So you guys will have a case study about Allison Mason. I think do you all have a copy of that?
It should be one of the handouts, right?
Yes.
So we're going to use the case study of Allison Mason to just frame the presentation today, and we will be reading it right now briefly, and then we'll be referencing it throughout the presentation. So I'm going to give you all about 2 minutes to read through it. Okay, has everyone had a chance to read through that? Okay, great. So let's get into the reason we're all here today, bad paper. So when people enter the military, they're promised that upon discharge, they will be considered a veteran, they will have access to healthcare, housing, benefits, education, etc. We're going to talk about the fact that a number of people, sounds like it's kind of echoing a little bit, a number of people are cut off from those benefits as a result of traumas that they might have endured in service. So bad paper refers to a discharge document that people receive when they're discharged from the military. Anyone who has served on active duty will receive a characterization of their discharge. So they'll get an honorable, general, uncharacterized, other than honorable, bad conduct, or dishonorable. And the vast majority of service members do receive an honorable discharge status and will be entitled to those benefits that they were promised upon enlistment. But a large number of people are not. So between the fiscal years 2000 and 2013, more than 600,000 service members received a less than honorable discharge status, impacting their eligibility for benefits. Not all bad paper is unjust. Certainly some people commit misconduct for which their access to benefits is then cut off, and that may be a just outcome. The cases that we work on are those where a service member is exposed to a trauma or numerous traumas. They then react to that trauma, manifesting mental health symptoms, and those mental health symptoms either result in conduct that is labeled as misconduct by the military and then booted out of the military. A low discharge status can then affect people's employment opportunities. It can limit eligibility for healthcare generally and mental health services specifically. It can impede access to disability benefits through the VA. Veterans will be denied education benefits. And in fact, people can also be prevented from even being considered a veteran. Homeless veterans, as you might imagine, are most hurt by this lack of access to services and benefits, as they already have limited means of obtaining these vital resources. So this is the bad paper that's referred to. This is a DD-214. This is a military discharge document that everyone receives upon leaving service. It basically is a snapshot of someone's service in the military. So it'll have their basic information, name, home address, birth date, social security number. It'll also have their dates of service. It'll have if they have any foreign service, what awards they received, what was their job, their military occupational specialty. And then at the bottom where the red arrow is, it will have their discharge status and their narrative reason for separation. And so if we zoom in, we can see that that little box at the bottom, this person received in box 24 a discharge under other than honorable conditions. And their narrative reason for separation is misconduct. And this is the piece of paper that if someone is going to have one document from their military service, it's going to be this. And if someone is trying to apply for a job and assert that they're a veteran, they might be asked for their discharge document and they'll have to show this. So I mentioned earlier that people with bad paper may be not allowed to consider themselves a veteran. So at Inner City Law Center, obviously anyone who served in the military, we consider them to be a veteran and call them that. However, the VA has very specific guidelines for who they consider to be a veteran and therefore is eligible for VA benefits. So for VA purposes, you have to meet both of the following prongs. One, you have to have active military service. And two, you have to have been discharged or released under conditions other than dishonorable. So the first prong, active military service, is if someone served after September 1980, the general rule is that if they serve 24 continuous months of active duty service, they meet that requirement. For people in the National Guard or reserves, it will be the full time that they were ordered to active duty. And there are a few other exceptions for people who qualify as having active military service, who served post-September 1980 and don't have 24 continuous months. If you served before September 1980, there's no minimum length of service requirement. The other thing, so this is the first step. The second step is whether someone was discharged under conditions other than dishonorable. So as you can see, if you received an honorable, a general, or an uncharacterized, according to the VA, as long as you also have active military service, you'll be considered honorable for VA purposes. If you received a dishonorable discharge status, you're going to be considered dishonorable for VA purposes. But it's the gray box, the other than honorable and bad conduct recipients, where it's a case-by-case determination that the VA will make. So there are these are the cases that we take on. There's basically, when someone has bad paper, there are two ways of getting them eligibility for benefits. One way is through the VA, and typically if you're taking on a case with Inner City Law Center, we'll be working on that case. The other case is through the DoD, and that's the discharge upgrade process, which is what you'll all be taking on. The only way to get someone's bad paper actually changed is the discharge upgrade process. But we can potentially argue that they should be eligible for veterans benefits through the VA if they have an OTH or a bad conduct. So just be aware of the fact that the person that you're working with might also have a simultaneous VA claim going on at the same time. One other thing to mention is there is a rumor that's still persistent to this day that upgrades for discharge statuses are automatic after 6 months after people leave the service. I don't know where that came from, but it has persisted for decades. And so that might be something that you hear your client tell you, that they were told that it would be automatically upgraded, and obviously that has not happened, so they need your help. This is a breakdown just of benefits that eligibility is determined based on someone's discharge paperwork. So you can see for VA healthcare, if they have an honorable or general, and they also meet that active military service requirement, they're automatically eligible. If they have an OTH or a bad conduct, they need to go through the VA process. It's called a character of discharge or a COD determination as to whether they're going to be eligible. Also notice for the GI Bill, only an honorable discharge status will get someone eligibility. So even if we're going through a VA process to get someone eligible for general VA benefits, the only way to get them access to the GI Bill is to go and get a discharge upgrade through the DoD. So thinking back to Allison's case, in groups of 2 or 3, let's talk about how a discharge upgrade would affect her eligibility for benefits. And then we'll take 5 minutes to discuss, and then we'll come back together as a group. All right. So, what do people think? What would a discharge upgrade do for Allison? And people in Orange County, I think if you turn on your microphones, we can hear you.
And the folks in this room should turn on the microphones too, if you just click and then see the green button and then talk.
Do you want to be
Anyone?
a leader, Alan?
She would be eligible for naturalization benefits and reemployment rights.
Yes. Anything else?
That assumes that you're upgrading her to general, as opposed to all the way up to honorable, which would be a much tougher slog, obviously.
That's a good point. So we typically, if we're applying for a discharge upgrade for someone with an OTH, we'll always argue we want an honorable. In the alternative, we'll take a general. And we don't have, so we have certainly seen more of a willingness to go one step as opposed to two, but we have seen a few cases where they'll go OTH to honorable if there's sufficiently mitigating circumstances. But yeah, this is assuming that she goes to an honorable, I suppose. I think I heard someone say the GI Bill. Yeah. Anyone else?
It's going to depend on which upgrade you get.
Let's say honorable.
Would she be entitled to everything with a D?
Yeah. Yes, exactly. Yeah. So the world would open up to her. It would be much easier for her to, especially if she is experiencing homelessness, she would be eligible for a housing voucher through the VA. She would be eligible for education benefits. She would be able to start getting her health care through the VA. It would make a massive difference. And she could also, one thing that I hear from a lot of veterans, especially women veterans, is that if they have an other than honorable and the VA then tells them they don't qualify for any VA benefits, it makes a massive difference to get that discharge upgrade so that you can say, no, I am a veteran. You know, in either case, they should be considered a veteran. But to be able to claim veteran status and to be able to say that they're eligible for all VA services can be huge for our clients.
Can I ask a question?
Yes, if you turn on your button.
That it was on. You turned it off. We're working on a case, May and I are working on a case where the person was discharged well before I think it was before the 20, you said 24 months?
Yes.
So if we're able to upgrade, do they get credit for having been in for the full time necessary? How does that work?
So what would happen for them is they would fall into one of the exceptions most likely. If that person is also service connected through the VA, then they would be, that's one of the exceptions. So let's say they're
so that
service
helps.
connected for post-traumatic stress.
Right.
Yeah. She would be eligible for health care for post-traumatic stress and also for compensation for that. And then generally for other benefits, she would be entitled as well.
Thank you.
Yeah.
No, I'm turning it off.
So again, this is what you can see a narrative reason. The reason for separation, it just says misconduct. So there's a number of reasons why you would get bad paper. And so it could be simple infractions, such as being late or disobeying a lawful order. It could be misconduct, which could be a couple AWOLs or disobeying multiple orders. You can also get bad paper for a serious offense, which could be going AWOL for longer than a year or for sexual misconduct. And finally, you can also get bad paper for civilian conviction. So if a veteran was on leave and robbed a bank or committed some other civilian crime, they could be discharged for that as well. And so the reason why the narrative reasons for separation are so important are a lot of veterans receive discrimination based on the narrative reasons. And like, for example, if it denotes drug use and they're applying for a job and their DD-214 says drug use, then there's a high probability that they might not get that job because the employer might not think that they're capable of doing the job. And even for like honorable discharge, they might want to change the narrative reason. For example, with don't ask, don't tell, they might have had a honorable discharge, but the narrative reason might say homosexual conduct. And again, they wouldn't want that on their DD-214s a lot of times. And so bad paper obviously and mental health coincide very often. And the types of cases we bring for discharge upgrades are usually always going to involve mental health related misconduct. And we take on the hardest cases. So these are cases where without an attorney involvement, our clients likely would not be successful with a discharge upgrade. Especially in terms of military sexual trauma, because most of the time they're not reporting that trauma. So we have to establish a case in order to show that the trauma existed without any allegations in their military file. And so post-traumatic stress is the development of emotional and stressful symptoms due to traumatic experience that they experienced in person. It could be a personal attack such as a sexual assault. It could be a physical attack like in combat. It could also just be witnessing these traumatic events. So even in certain jobs, like I have a client who was a surgical assistant and so is constantly, dealing with body parts or dealing with death. Even that can create, post-traumatic stress. And it's also important to note there's post-traumatic stress, and you might hear post-traumatic stress disorder. A lot of vets don't care, but some might, and some don't like the disorder part of it. So it's usually safer just to refer to it as post-traumatic stress first and just go off of how they respond to it. And then finally, and then also military sexual trauma, and that is obviously, either ongoing sexual harassment that they experience while in the military or sexual assault as well. And traumatic brain injury, a lot of times, obviously, it's a severe brain injury, and it can affect the cognitive and behavioral functions of a person after the fact, which again can lead to a lot of misconduct. And so a lot of the misconduct or the behaviors that are produced are mental health related. Or they're also related to treatment of those mental health disorders. We've had a client in the past who had a prescription for insomnia, and so he was falling asleep during his training, and so he was booted from the military based on that. But again, those were symptoms of his medication that he was taking because of his disability. And again, there's other mental health related misconduct that you're going to see a lot of times in these military files. Some examples could obviously be going AWOL. There's a number of reasons why people would go AWOL, especially, for example, in military sexual, in an MSD case, if the person doesn't want to be, it could be a commanding officer that was the assaulter and they don't want to show up, right? They don't want to see that person, and so they might just go AWOL. Testing positive for prohibited substances, marijuana use, they might be self-medicating. And then obviously substance abuse, it's closely related to mental health disabilities. A lot of our clients will self-medicate with marijuana or other form or alcohol, and the VA just doesn't see it that way. They see it as culpable behavior and misconduct. Marines who deployed to combat and were diagnosed with PTSD were 11 times more likely to receive misconduct discharges than those who were not diagnosed with PTSD. They were also 8 times more likely to have substance abuse discharges as well. And so the way that military discharges work, it's important to know that this falls under military law, and one of the, I guess, main downfalls of military law is it's very discretionary. So you might see two people with very similar behaviors receive completely different discharge statuses. And so there's a number, there's non-judicial punishment, or NJPs. And those are essentially, they don't get any type of trial. They get to just, their commanders get to administratively discipline the service members. And so this can include a lot of things. It could include bread and water rations. It can include a decrease in pay. It can include, what's another one? Correctional custody or extra duty and other restrictions. And then finally, they might also get court-martialed. And so there's 3 different types of court-martials. There's summary court-martial, which is for relatively minor misconduct. And court-martial is actually, it's very similar to a criminal trial. This is where they'd actually go to a trial and have someone adjudicate their guilt and determine the punishment that's going to be involved. There's special court-martial, and special court-martial, here's where you're going to have a military judge, you're going to have a prosecutor, you're going to have defense, and you're going to have someone who's, 3 officers who are going to decide the guilt as well as the punishment. And then general discharge or general court-martial is the most severe, and this is actually potentially punishable by death. Finally, the last area of discharge that you may see are called Chapter 10 discharges. And these are similar to, I guess, plea deals in a way, where they can say, all right, you don't have to go through the court-martial proceedings if you just, request a discharge. And this is supposed to be something that is completely up to the service member. They're not supposed to be pressured into this decision. Unfortunately, a lot of times they are. So it's similar to plea deals in that respect as well. And again, the military does not treat disciplinary infractions as a symptom of mental health related disorders. So they might have early onset of symptoms, even schizophrenia, they might have early onset symptoms of that, and the military is not going to recognize that as related to a mental health condition. And even if the military has acknowledged a disability and is processing a medical discharge, they can suspend the medical separation process and just give the person a misconduct discharge. And a great example of this would be for if they had a back injury and they were going through a medical discharge process, and in the meantime they were self-medicating for that back injury using marijuana. They could then stop the medical separation proceedings part of it and just go straight to giving them a bad discharge or discharge for misconduct. And then we have examples of the discharge paperwork in the handout. It's page 7 and page 8. So on page 7 and 8, these are what you would probably be looking for in the client's military file. So on page 7 and page 8, this is where you would look for example, in a military file, to get more details about the discharge. So back to Allison's case. What factors should Allison's command have considered when discharging her? You guys can sit and think about it for a little bit. Has everyone had a chance to review Allison's case? So what factors should they have taken into consideration in the discharge process?
Yeah, so I think there would have been allegations of sexual, harassment and
Yep.
possibly the MST, military sexual trauma.
Definitely.
I think there's also hazing issues, which I know
Yeah.
should be taken seriously and sometimes actually is.
Yeah. That's great. Any other specific things that you guys saw?
Pain,
I'm sorry?
physical pain.
The physical pain, yeah, physical pain, physical injuries, yeah. There's a big one near the end.
Yeah, the failure to consider potential PTSD. Right?
Yes.
Yeah.
And why do you say the PTSD? What do you think was the big trigger when reading that?
Oh, just that there's no evidence that they gave a PTS evaluation or considered mental health diagnoses. Yeah.
Sure. And I think, right, she stole a gun and hid. Like, that's a pretty drastic response and something that should probably raise red flags to someone that there's maybe an issue with PTS going on, right?
Yeah. Yeah, and I think, if I could just comment, like I've had cases, it's almost like it's a compounding problem, because not only is the branch of service not considering PTS, but the symptoms of the PTS, which could be acting out in this way, attempts on your life, destructive behavior, become the reasons why they get discharged.
Exactly.
For other than honorable purposes. And so it's, not only were they not being treated for the root problem, but the symptoms of that problem become a problem themselves.
Exactly. Yeah. Anyone else? I think we covered most of them, but there's still a couple. Okay. So I think we're going to go ahead and take a 5-minute break and then resume.
Okay, so I think we're ready to get back to it. So now that we've got a backdrop of what bad paper is, what effects it can have on someone's eligibility for benefits, and then how they might have actually ended up getting that bad paper, let's talk about the process that you're actually going to go through in representing clients in a discharge upgrade. So you have to exhaust your administrative options prior to doing anything in federal court. So you would either be going to the Discharge Review Board or the Board for Correction of Military or Naval Records. And every branch of service has a DRB and a BCMR, except for the Marines, which uses the Navy's boards. So few differences between the DRB and the BCMR, but generally speaking, our rule is that if you can go to the DRB, go to the DRB. Because you get more than one bite at the apple, so to speak. At the DRB, there's a 15-year statute of limitations from the time that someone was released from service to apply. If it's been over 15 years, then you do have to go to the BCMR. You can also apply to the DRB, get a reconsideration at the DRB if you get denied. If you get denied again, then you can go to the BCMR. The BCMR is very flexible with their 3-year statute of limitations if you can show good cause for why it should be waived. The DRB, however, has a very limited ability to make changes. So really all they can do is change the discharge status and change the narrative reason for separation. In most of our cases, that's what we want, so that's why that's the best option. But there are some cases where you might have someone who wants to re-enlist, and so they need their re-enlistment code changed. And you have to go to the BCMR in order to make that happen. If you want a mixture of change in discharge status and change in re-enlistment code, we still recommend that you go to the DRB first if that's an option, just because, again, you get more than one chance to have your argument as to why a discharge status should be upgraded. The DRB, so I mentioned there you get more than one bite at the apple with the DRB. So what that means is that you can do a records review filing first. And then if you get a denial, you can actually request a hearing. The downside is that the hearings are only in Washington, D.C., so you would have to go there with or without your client. And then the BCMR only really has records review. They have the ability to grant a hearing request, but they do it in very rare cases only. A note on hearings, we have had the most success in cases where people have gone to hearings to actually have their case heard. And this is the case even if the veteran themselves has not been able to go. But I think that having face-to-face contact with the board hearing the case makes a big difference, particularly because these boards have thousands of applications to review every year. And there's some absurdly low number of minutes that they have to review each application. And so if they can actually hear directly from you instead of trying to sort through, tens or hundreds of documents, you're much more likely to have a successful outcome.
Can I actually make a comment?
Please.
And to talk about this kind of 2 bites at the apple, it's interesting because especially for litigators, it's kind of a combo between an appeal and just refiling, because you can actually, if you get denied the records review, you have the opportunity when you request the hearing to draft an entirely new brief and submit new evidence and everything. That's correct, right?
Yes.
And so you're not tied to the arguments that you made in the initial runaround, but you can reassert them. And in addition, you can address the opinion that you got from the records review. And try to kind of fill those gaps, or at least the gaps that the board thought were in your brief the first time around. So it's a huge advantage to be able to have 2 shots at it. And then obviously, if you can do it in person, it's also a huge advantage. So,
Would you be back before the same 5 officers, or would?
No, it would typically, just by virtue of the fact that the length of time between when you would have your first decision and when you would actually get a hearing, it will probably be at least a year or two. So that would mean that it would most likely be a totally separate group of people. So there's a massive presumption in favor of the government in these cases. There's the presumption that the government acted with regularity in discharging any former service member, and that must be overcome with substantial, credible evidence. So we can attack discharge statuses by arguing either that they were improper or inequitable. And just to note that improper or inequitable are terms that the discharge review boards use. The BCMR uses error or injustice, but I'm just going to refer to improper or inequitable just for sake of ease. So the first way that you can argue that a discharge was improper is by stating that there was an error of fact, law, procedure, or discretion, and that error was prejudicial to the veteran during discharge. So an example of this would be if there was ineffectiveness of counsel at a court-martial, if there was an ineffectiveness of unit leadership during discharge process, maybe the command applied incorrect regulations, or maybe they failed to apply the correct regulations in discharging someone. The second way that you can attack a discharge status on the basis of impropriety is by arguing that a change in policy has been enacted and expressly made retroactive. So the most straightforward of this is repeal of Don't Ask, Don't Tell. So one would think that perhaps when Don't Ask, Don't Tell was repealed, the military would automatically upgrade anyone who had been discharged under that policy. Unfortunately, that's not the case. People have to apply individually in order to get their statuses upgraded. So moving on to arguing that a discharge status was inequitable. The first way that you can do that is by arguing that the discharge was inconsistent with disciplinary standards at the time of discharge. And you can pretty easily find the disciplinary standards for each branch of service on the internet. You can also argue that a discharge was inequitable because current discharge policies and procedures are materially different than those that led to the veteran's discharge. So, for example, in 2009, a law was passed that mandated medical examinations prior to separation for all service members who were diagnosed with or who were reasonably asserting post-traumatic stress or traumatic brain injury. And without reviewing this medical examination, the service could not characterize someone's discharge as less than honorable. So for people who would be representing veterans who have less than honorable discharge statuses and served and were discharged prior to 2009, you can argue that had they been afforded this examination, there's substantial doubt that they would have received the same discharge characterization. Also, you can look through the file, and if they haven't had this examination at all, you can attack the discharge as being improper because the military failed to follow their own regulations. So the third example, or the third argument that a discharge was inequitable is based on evidence relating to quality of service or capability to serve. So quality of service would refer to someone's rank, responsibility, awards, whether they had combat service or prior military service, basically arguing that looking at their overall service, would it be inequitable to brand them with a less than honorable discharge status? The capability to serve part is where a lot of our arguments regarding mental health come in. So did something affect this service member's ability to serve? For example, post-traumatic stress, traumatic brain injury. Capability to serve can also include factors such as discrimination or arbitrary and capricious action by individuals in authority. So I think at least two of the cases that we brought today involve racial discrimination and sexual discrimination. So you could use that argument for these cases. So there have been really positive policy changes that have come from the Department of Defense recently that make me optimistic about the fact that the boards will start to get these decisions correct. But before I talk about those, I'm going to tell you how they have been getting it wrong for the past few years. So first, the boards will apply a strict right from wrong standard, and they will only excuse a veteran's discharge-related misconduct by reason of insanity, and after a showing of a low degree of cognitive functioning. This stricter standard really fails to comply with the extenuation or mitigation standard requirements set forth in the law, and it frequently results in inequitable decisions. We also see a wide range of failing to apply applying the right from wrong standard or failing to apply mitigation across the board. So whereas the Air Force might be really good about understanding that how to look at PTSD as a mitigating factor in someone's discharge-related misconduct, the Navy, for example, is much harder on its former airmen or former Marines, and typically will apply a stricter right from wrong standard, and therefore they will upgrade a lot fewer discharge statuses. Another thing that we see is even if we are able to get someone's discharge status upgraded, the board will still refuse to change a narrative reason for separation. So they'll argue that in not so explicit terms, but they will state that the veteran should still have misconduct or drug use written on their DD-214 because they did in fact engage in that behavior. However, we understand why they did, so we'll upgrade their discharge status. So now that I've told you about how the boards have been getting it wrong, I'm going to talk about the recent policy guidance that I think will result in a change and will make for more successful decisions. First was the Hagel memo that came out in September 2014. So this directed BCMRs, and not DRBs, to apply liberal consideration to applications raising the issue of post-traumatic stress as a mitigating factor in discharge-related misconduct. So although this was already what the board should have been doing, the Department of Defense recognized that they weren't doing it, so it scolded them very lightly. It also said that the board should pay special attention to VA service-connected PTSD or PTSD-related conditions. But there wasn't a ton of positive change after the Hagel memo came out. The Carson memo came out in February of 2016, and it expanded the Hagel memo to cases involving not just PTSD or PTSD-related conditions, but also traumatic brain injury. It also waived the statute of limitations for applications with Hagel memo relevance and provided for de novo review of applications considered prior to the Hagel memo. That didn't do a lot either. The National Defense Authorization Act of 2017 made a positive step in that it required boards to make discharge upgrade claim and disposition data available quarterly. It also required DRBs to accept VA and civilian medical evidence, and it codified the PTSD liberal consideration standard. The best of them all is the CURTA memo that was just issued quite recently in August of 2017. And this really broadens the scope of application. So it, whereas the Hagel memo explicitly addressed BCMRs and other than honorable discharge statuses, the CURTA memo explicitly says that these lowered standards should apply to general discharges. It should also apply to narrative reasons for separation, re-enlistment codes, anything that could be changed on someone's DD-214, really. It also broadened the application to all mental health disabilities and all applications based on sexual assault or sexual harassment. The CURTA memo also explicitly tells veterans to answer the following questions in their application. So, did a veteran have a condition or experience that may excuse or mitigate their discharge? Did that condition exist or did the experience occur during military service? Does that condition or experience excuse or mitigate their discharge? And does that condition or experience outweigh the discharge? So we are recommending that people taking on these cases explicitly answer these questions in their applications. Yes.
Do you guys recommend, do you recommend citing and quoting these memos in the briefs?
100%.
Right? Okay.
Yes.
But it is the case, though, that the boards are supposed to be considering these standards on their own, right?
Yes.
But sometimes it helps to remind them or integrate it into your case, I guess.
I think so.
Yeah.
Yeah, absolutely. Just a gentle reminder that we're aware of the policy guidance as well.
Where can we get copies of each of these memos?
So we will be sending these to you in the records that we place. So for any case that we place with an attorney, we will send you, the records that we have on file. We'll send you these memos. The CURTA memo I've actually included in your materials, but also they're easily Googleable, but we'll definitely send you them.
Thank you.
Mm-hmm. Okay, and so it's the CURTA memo that finally makes an attempt at defining what liberal consideration actually is. So liberal consideration includes a recognition that some circumstances should result in a lower evidentiary burden. Mental health conditions may go undiagnosed for years after a stressful event has occurred. Mental health conditions affect people differently and result in behavior that might not be expected. VA service connection is persuasive evidence that a condition existed or an experience occurred in the military. And that is the fact that the VA service connection should be a factor in someone's discharge upgrade application means that we are typically applying for VA service connection first and doing the character of discharge application first, so that then we can pass along that evidence to you in support of someone's discharge upgrade application. Certainly, there are some cases where we're not going to be able to get someone service connected because their discharge status, the VA considers that to be disqualifying, but we will typically try to give you that evidence to use. Liberal consideration also includes the recognition that the relative severity of some misconduct can change over time. So the best example of this is marijuana. So the military finally realizes that marijuana is legal in some states, and so that fact means that perhaps they should not treat marijuana as though it's on par with other more serious conduct. And then finally, I think something that's very helpful in the CURTA memo is the recognition that an honorable discharge status does not require a flawless record. We had a client who went to a personal hearing in Washington, D.C. He was represented by a pro bono attorney, and one of the people on the panel, the veteran was discharged with an other than honorable due to 2 instances of marijuana use. And one of the people on the panel asked him, well, I haven't committed, there are no infractions on my record, so do you really think that we should get the same discharge status? Wrong for many reasons, but that exchange happened prior to the CURTA memo, so it's my hope that that kind of thing could be more easily shot down now that we have this explicit guidance from the Department of Defense. A few additional considerations in working up your cases is the 2009 law about medical examinations that I mentioned earlier. And then also in applying for discharge upgrades, if a veteran is asserting post-traumatic stress or traumatic brain injury from deployment in their discharge upgrade application, then the DRB must include at least 1 medical professional, and a final decision should be expedited. After the CURTA memo came out, prior to the CURTA memo coming out, we were waiting probably 12 to 18 months for decisions. After the CURTA memo has now come out and people are taking advantage of the fact that the Department of Defense is really explicitly telling these boards to understand that the effect of mental health can have on someone's behavioral function, the boards are getting more and more applications. We're now telling people that they can expect probably at least a 2-year wait. It's really taking a long time, and I don't think they've gotten additional staffing since the CURTA memo came out. I'm not sure about that though. So what types of evidence do we think would be helpful to submit with Allison's discharge upgrade application? We can just brainstorm.
Therapist, I mean, some sort of like medical expert on like depression, honestly, all of them.
A letter from a medical expert. Absolutely, yes. If we can get someone to state that her misconduct was directly linked to her mental health condition, that's one of the best pieces of evidence we could submit. What else?
Evidence of the conduct of the incidents that she underwent that led to those conditions.
Right. So the sexual harassment.
The hazing,
The hazing.
all the things that are described, yeah.
Mm-hmm. What? How would we show that those things happened?
Well, there'd be testimony from her.
Mm-hmm.
If you could get any third-party witnesses, you'd try those as well.
Yeah, and I think, you're implying a lot of people certainly don't feel comfortable reporting, may also not feel comfortable telling people.
There might be records of those incidents if she reported them at the time.
Yes, if she reported them at the time, absolutely. Most of the time they won't have, but certainly they might have called an aunt or told a friend, and they might still be in touch with the family member or the friend. We have a lot of people who've now, connected over Facebook, and so we can track down that person and try and get a letter of support from them.
I was going to say the fact that she was not given a medical exam before discharge.
Yes, definitely. A good point to argue.
Would a medical exam include a psychological or psychiatric evaluation of some sort?
It should. If the person is diagnosed with or reasonably asserting post-traumatic stress or traumatic brain injury from a deployment or sexual assault. The problem with that is a lot of people don't want to identify as having any mental health symptomatology, let alone a diagnosis. So I think that the military often fails to give these examinations because they're unaware that they should be giving them, or they don't make proper efforts to figure out whether they should be giving them.
And I guess in this particular case where she was denied VA benefits, that means there would be no VA file reflecting any of that either. Is that correct?
So there would be a VA file, and certainly, so in the cases that we work up, we will be getting some of these support letters. I think what we want in a support letter for the VA might differ slightly than what you might want for a discharge upgrade application, but we can revisit those same witnesses. We will also, supply you with any evidence that we've submitted. But certainly if she has been denied VA benefits, there won't be a decision linking her trauma or her misconduct to her time in service.
But would there be an evaluation in the VA file?
There should be. So what the VA is supposed to do, let's say that we have someone who is alleging that they were sexually assaulted and they have post-traumatic stress as a result, but they also have a disqualifying discharge status. What the VA is supposed to do is, even if they say, we don't think you're eligible for compensation for this disability, most of the time they are supposed to at least schedule an examination to determine whether the disability is related to service and would therefore qualify that person for healthcare for that disability only. The VA rarely actually does that. So the answer is there might be, but it would be in the rarest of cases.
Another related protection here, this might be specific to the Army, but a case that I was working on, there's a requirement during discharge that if there's an allegation of sexual, either harassment or assault, I think sexual assault, there has to be a formal determination as to whether the assault relates to the reason for the discharge, I believe. And so you'll have, if there has been a notification of a sexual assault, they have to like have this additional paper that is signed by the superior officers where they've made a determination that the reason that they're being discharged is not related to the sexual assault, I believe. And so that's another thing to challenge, but that might be Army specific. I'm not sure.
Yeah, I wouldn't be surprised if there were similar rules in place for other branches of service that just might not be uniformly followed.
Get like an expert training witness to say that like the sand crawl is like something that's not done or like something like that? I mean, would you find someone that was willing to declare that?
I think that's a fantastic idea.
Oh, Henry, sorry.
So we have not had a veteran on staff for about a year, but I am very excited because we just hired an Army veteran who's starting Monday, so we can definitely go to him with these types of questions. Yeah, and we also have other people who have military experience who we can go to kind of gauge whether or not this is the average experience. But I think getting, either if there's a handbook for basic training, or if there is actually an expert who can write a letter stating that sand crawling is not something that they ask the average soldier to do, that would be extremely helpful.
And so veterans on staff are a great tool. They can, point you the right direction, on things, but they can also just kind of give you a practical impression on, what the officers on the board are going to be thinking. I know Henry clued me in on a lot of the attention that hazing had been being given, and so advised that we emphasize hazing type allegations. That was very helpful. And then also Manat, at Manat we do have veteran attorneys as well, who can be I think helpful in an advisory capacity. So those are all things to think about.
Yeah, absolutely.
That's a great idea. We should get it. Yeah, I don't know if I don't know if Ethan will hate me for saying this, but Ethan Roman in New York, mid-level associate, was in the Marines, and I know I've talked to him about certain things, and he's willing to help out with these cases. So, but yeah, it would be great to get a
You
list.
should talk to Gisela. Is there somewhere we can put together a list like that of veterans in the firm?
I'm sure human resources have that list.
Can you check that with HR? Thank you.
Great. All right, I will turn it over to Amanda.
So now we're going to talk a little bit about the procedural guidance of preparing an application. So there's a number of tasks that are going to take place: requesting records and review. We're going to have most of the records that you're going to need for this. Obviously, requesting letters and things like that would be helpful. But obviously, any of the medical records or the military records we're going to already have, so you're not going to have to request those. You're going to work with the client to create timeline of events. You're going to interview the client, build some rapport, gather supporting documents, which is going to include a number of things. We've already mentioned quite a few: expert testimony, education, military records, VA records, and the specific records, right? Because while they do have access to all the military records, it's important that we send the relevant specific ones to be sure that they looked at the right ones. Some other things you could include would be community service documentation, just letters of recommendations from employers, other people. Really, there's some other maybe case-specific ones, the sand crawl, an expert testimony for that. That would be awesome. And so then you'll submit the brief and wait 18 plus months for a decision. Probably more on the plus side. And so when you're taking on a case with Inner City Law Center, like I said, we'll request the records. So the other things we'll do, we'll provide the material bank, which will include, everything I mentioned before, their medical records, their military records. If we submitted a benefits application, all of those relevant things, we'll link you guys with the client, and then we'll attend the first meeting and help you strategize, or if you have any questions, procedural questions, or just questions, about anything really. And we'll review and edit applications and briefs as you see fit. And you'll get those material banks as soon as you decide to take on a case. So. And again, material bank, we might already have buddy statements and we might already have declarations from the veteran, but you'll also get samples of all of these things. And so when you're trying to figure out what you would like a medical expert to say, you can look at our samples that we've used in previous cases. And because there's so few actual deadlines in these cases, we've kind of created a timeline just to keep the case moving forward. Again, these aren't hard deadlines, and if you want to go on.
Yeah, I can say a word about timing. So I think that a major benefit of these cases is that you are not on a hard, there's not a filing deadline per se. That helps us. We're all busy Manat attorneys. That helps us if you're having a slow day, if you're having a slow week, you can take this on and you can kind of work up the brief. It's very helpful to be flexible like that in that way. That said, because these are taking so long to get through the boards, we have to stay disciplined on generating the briefs and getting them filed. In addition, you may actually draft the majority of the brief, and a lot of times the client might kind of go missing and you can't contact him for a signature or for approval, him or her. Maybe you just determine that you need an additional letter from a friend or someone, and it takes a while to track that letter down. So there's always, even if you're 90% done with the brief, there's a lot of times things that will really delay it on the back end. So we do encourage everyone to really prioritize this stuff, even though there's not a hard deadline. And I think to facilitate that, ICLC will have some, deadlines, and it's really a matter of months. It's not a matter of days or weeks. So we can really stay flexible, and I think that's completely okay. But we will be pushing some deadlines, I think.
And a side note to that, if you are having trouble getting in contact with a client, let us know. We're pretty good at tracking people down, so definitely let us know right away, and we can help.
Including tracking you guys down if the brief is taking too long. No, I'm just kidding. I'll be doing that.
So now we're moving on to culturally competent practice. So all of these cases involve at least one traumatic event for our clients. We've already established that those happen, they exist, and this is a credible case before we give it to you guys. So just keep that in mind when you're asking the client questions. Really let them kind of narrate the story and go at the pace that they seem fit. And a lot of times just be aware of how you're reacting, because you're going to hear some shocking things. A lot of this is sexual assaults or war or, just military life. And so just be mindful and react appropriately. And although obviously, like some of our veterans are going to have combat experience, and so in terms of trying to create the case, you might be tempted just to ask, like, have you ever killed anyone? Have you ever seen anyone get killed? Be gentle with it and let them dictate when that comes up. Be careful with thank you for your service. I know a lot of times that's like what we're told to just say to veterans, but there's some things to keep in mind when it comes to that. Obviously, Vietnam veterans, a lot of them were draftees and have a general distrust for the government as a whole, and so keep that in mind when you're interacting with that veteran. And also veterans who signed up to be in the reserves. A lot of them didn't ever foresee themselves going and being deployed. They thought it was going to be 1 weekend a month, 2 weeks a year, and ended up in full deployment. And women in combat, I think there's a general misconception that women are not involved in combat and that it's just not true. So keep that in mind too, that even though if you're dealing with a woman veteran, that she may still have some traumas from combat. And contrary to popular belief, not everyone is a soldier. So obviously, if you're in the Army, you're a soldier. If you're in the Marine Corps, you're a Marine, Navy, sailor, Coast Guard, Coastie, Air Force, Airman, Airwoman. And as you can see, I mean, we're focusing a lot on the trauma. All of the veterans that we send you guys, like I said, have had some sort of traumatic event that they've experienced. And so everyone experiences trauma differently. There is no normal response to it. And any behavior, when you're looking through trying to corroborate, these allegations of misconduct or these traumatic events such as military sexual trauma or any other traumatic event, you're going to be looking through these files to try to find supporting evidence. But it's important to know that so any negative response, great, you want to be like, well, that was a symptom of their PTSD. But even positive responses doesn't mean that the trauma didn't happen. Someone might have just then focused in on their work and tried to over control that aspect of their life. And so all of it can be an effect of the trauma that they experienced. And so just being as transparent as possible in the process works the best. So explain the purpose of the interview ahead of time. Let them know about how long it's going to take. If you're going to be talking about traumatic things, then give them a heads up that, hey, we're going to be kind of diving into some of these things. If you're comfortable with that, when is a good day for you, right? Because some days it might not be a good day to get into that. And so we want them to have a heads up of what the content of the conversation is going to be. And so that way also they can make any follow-up appointments they might need, right? Maybe they want to schedule a meeting with their counselor or therapist, or go to a group after discussing this stuff. And so again, just also be aware of your own reactions, and the timeline really is on them. So if you think you're going to get through 3 of these traumatic events in one meeting and they can only deal with one, then schedule another meeting, right? They're in control of the process, and don't push them to do more than they're kind of ready to at that point. And environment is very important. You want to make sure that they feel safe and comfortable, when they're talking about very intimate details of their life. Obviously distraction-free and confidential, so there's not people walking around and they feel, rushed or distracted when talking. And just equal physical position, mirror kind of whatever they're doing. If they're sitting down, sit down. And it's great to start with open-ended questions, letting them kind of just go on their narrative. And while they're doing that, you're going to hear a lot of great things that you're going to zone in on that maybe they don't know is important. They might say that they went to get medical attention and just blow past that, and you realize that that's a great thing that you want to document and find a record for that. So, jot that down when they're talking and come back to it. You mentioned you went and got medical attention. What happened then? Can you tell me more about that? It's best just to keep them talking, because you'd be amazed at what they don't necessarily think is important for their case, but is very important to us to know. And a lot of times they might, the details might be a little hazy, especially surrounding the trauma. it's a very normal response. And so you might be trying to lock down dates and they might not be able to give you dates. So asking questions that are going to help refresh your memory. Was it cold out? Was it hot? Did this event happen before or after boot camp, or before or after this other event? Being able to help them narrow it down is very helpful. And then also just providing follow-up letters about what you guys did. It's great too, because then you're not having them questioning what's going on in the case and calling you and being like, what are we working on? I don't remember. And a lot of our clients have other, mental health issues or traumatic brain injuries. And so memory and things like that are tougher. And so if they have something that they can reference, it's just going to be more helpful for you guys and for them. And then, so here's just an excerpt from a declaration of a veteran. At that time, I didn't feel safe talking about the rape. Fellow soldiers were harassing and threatening me. Some of the threats were direct, some were indirect. They would tell me to keep quiet or you never know who's going to get you. They would say that if I went to another duty station, they knew someone there and they could hurt me. Basically saying I would never be safe and they could always get to me no matter where I'm at. So I kept my mouth shut because I was terrified of being hurt even more. And people first language always. No one wants to be defined by a single trait, especially maybe a medical condition or something that maybe they deem to be a negative aspect. So, people with disabilities, not handicapped, or Bob has a mental health condition, not Bob is mentally ill. And here is our contact information. So Kara's is at the top and mine. If you have any questions, obviously you can email us at any time. Yeah. Does anyone have any questions right now? No? And also just to note, one of the cases, I'm the attorney on the case, and it's a really great case, and you guys should all fight over it. The other two are I'm sure just as good, but. Orange County, we're trying to get you on the screen.
Yeah, I don't know how.
We're here. I don't know how to get the camera going though. Oh wait.
So I think I saw
Wow.
Kelly and Jordan there. Who else? Is anyone else there? We
David
can't see you
Smith?
right now. Oh, hi, David.
Hi.
There we go.
Oh.
Okay, so can you guys see us, or are you looking at the PowerPoint?
Yeah, we can see you.
Okay, great. Okay, so I think hopefully everyone's had a chance just maybe to look at these case summaries. And before I free everyone to go, if we could have volunteers, we could just start with the first case. These all look like, great cases with a lot of, a lot of stuff to argue here. The first one here, OIF, combat veteran. OIF stands for Operation Iraqi Freedom. Yeah. Which was the Iraqi campaign from 2003 to whenever it officially ended. OEF, Enduring Freedom, is the Afghanistan campaign that I guess is going to the end of history. But you'll see those acronyms. Does anybody? And I know I said earlier, but we need a partner, at least one partner on each case, and then at least one associate. And if it's a first-time associate, I think if we could staff it with two. That would be great. Do we have any volunteers for the first case? Don't be shy.
I'll take it.
And was that David?
Yes.
All right, great. Thank you. Okay, any associates want to work on this one? We can follow up later. Okay. Do you guys want to do rock, paper, scissors? We'll figure it out offline. Okay, next case. Veteran seeks discharge upgrade because of racial discrimination. I know, Alan and May, you guys just took one. You guys just have one, so you're probably full. Yeah. Yeah. Okay. We'll find somebody. I think I saw. Is Kelly not there anymore?
She had to leave a little bit ago. Yeah.
I'll follow up with her because maybe she can take that one. Okay, and then the last one. Anybody? I may be taking that one, but we'll figure it out. Okay. All right, everybody. Well, thank you for attending. And if you have any questions, ICLC is great, incredibly responsive. These guys know what they're doing. And then I can also try to answer any questions you guys have. So just don't hesitate to give me a call or shoot me an email.
And thank you.
Do you need anything from us on the MCLE?
Yeah. Jordan, we'll send over a sign-in sheet and certificates to get that handled. All right. Thanks everyone.